Good afternoon. Good afternoon in UK, United Kingdom, as well in Zambia. Today we have a match by the Quarks Foundation, the Inter-University Law Debate Tournament, 9th edition. We are in the Group C, and we have a match between King's College London in United Kingdom and University of Lusaka in Zambia. So I give the floor to my colleague.
Thank you very much, and good day to the two teams. And of course, a big thank you and good day to the three judges observing this debate. The topic for today's Day 3 match is whether or not international stock markets must impose systemic risk reporting obligations on multinational listed corporations. Of course, before we find out the positions for the debate, I will be passing the floor for introductions to the teams, starting with King's College London, Ms. Tabari.
Hi everyone, I'm very happy to participate today.
Welcome from University of Lusaka, Ms. Mukeya.
Hello, good afternoon. My name is Elizabeth Mukea.
Welcome from King's College, Ms. Garcia.
Hello everyone, I'm Kalita and I'm excited to debate with everyone today.
From University of Lusaka, Ms. Kabwanda.
Hello everyone, my name is Dawn Kabwando from the University of Lusaka. Thank you.
You're welcome. From King's College London, Miss Ali.
Hi, I'm Afreen, and it's an interesting topic. It should be an interesting debate.
Thank you. Welcome. And from University of Lusaka, Tando Miguel Ndlela.
Hello, everyone. My name is Tando Miguel Ndlela, and I'm so happy to be here.
Thank you and welcome. Also, a big thank you for the support of the two teams. They're supported by the coaches for the University of Lusaka. I believe it is Joy Ketiwa Zimba Mutale and Mwika Musakuzi. And for King's College London, it is Sofia Guzminova and Carla Roth. In a short moment, you should be now able to see the wheel and the randomizer for the allocation of positions. Screen, yes.
So do you see the screen?
Yes.
Okay. So as you can see, there are two possibilities for the two institutions, either to be in favor or to be against. The team will be in favor. We're starting with the first introduction for this match. So for this match, King's College London will be in favor and will be starting with the first introduction. As a consequence, the University of Lusaka will be against the motion. Concretely, King's College London will be defending the position international stock markets must improve systemic risk reporting obligations on multinational listed corporations. On the other side, University of Lusaka will defend the position that international stock markets do not have to impose systemic risk reporting obligations on multinational listed corporations. Now you will have 5 minutes to review your notes, and then we'll hear the introduction by the team from King's College London.
Thank you very much. Your time for final preparation has now passed. We'll begin by hearing the opening statements for the in favor position. The debate team of King's College London, you have 4 minutes.
Prediction, prevention, and protection. This is what systemic risk reporting obligation will increase to the financial markets and systems. And before we come to proving this, I would like to define the motion. International stock markets are global exchanges in which the shares of publicly listed companies are bought and sold, such as the New York Stock Exchange or the London Stock Exchange. Multinational listed corporations are corporations listed on multiple stock exchanges. And finally, systemic risks are risks that threaten the stability of wider financial systems and markets. Today, we will prove to you 1. Why there is a need for a systemic risk reporting obligation. 2. Why this obligation should target multinational corporations. And 3. Why stock exchanges should be the ones to implement the systemic risk reporting obligation. Starting off for why there is a need. Systemic risk reporting obligation is essential as it will increase transparency and add another protective layer against financial crises from occurring. Transparency is essential so that investors can regulate the stability of companies, as undisclosed risks can cause collapses that can affect multiple markets. An example of the consequence of the lack of transparency is the Enron scandal in 2001, in which a US multinational listed corporation had hidden billions of dollars in debts, and its collapse caused thousands to lose their jobs and thousands to lose investor pensions. Adding a systemic risk reporting obligation would increase transparency and the protective layer to avoid this. And this protective and additional protective layer has already been applied to banks. A systemic risk reporting is specifically referred to in the Dodd-Frank Act, which was passed in the US following the 2008 financial crisis. This act allows the US Financial Stability Oversight Council to break up large banks that are deemed to impose systemic risks. Naturally, by analogy, if banks are too large to fail, then multinational listed corporations that can affect entire systems should also be regulated on the basis that they can cause systemic risks. And this ties into our second point as to why systemic risk reporting obligations should specifically target multinational listed corporations. And this is because their size and interconnectedness means that their financial activities affect more than just themselves, but the financial market as a whole. Other companies, other employees, consumers, governments, and individuals are affected by their collapses. Therefore, an entity that can cause such widespread economic harm should naturally be subject to stricter transparency and regulatory obligations. And this reasoning has legal basis. For example, the Dodd-Frank Act, again, in its section 165, implements stricter regulatory obligations for firms which are interconnected and large. Additionally, the Sarbanes-Oxley Act, passed in 2002 following the Enron scandal, also increases disclosure obligations. Therefore, this shows that there's a legal precedent for the reasoning that because multinational listed corporations have such vast impacts on markets, they should be subject to stricter reporting obligations. And finally, our last point as to why stock exchanges should be the ones to implement this. And this is namely because they are effective in doing so. A study done in 2003, published by the S&P Global, used a sample of 46 countries and 43 stock exchanges and found that firms listed in self-regulating stock exchanges are associated with higher liquidity and transparency as opposed to firms in government-regulated exchanges. And this is because transparency is greater in self-regulating firms as they have better insider trading rules and disclosure rules. And therefore, a transparent authority will naturally receive transparency enforcement by its subjects. Therefore, we see there's no valid reason to not add another protective layer of implementation of systemic risk reporting obligation. And this will benefit not only the financial markets as a whole, but everyone who's affected by their collapse. Thank you.
Thank you. For the opening statement in the against position, University of Lusaka, 4 minutes.
I'll start in a countdown of 3, 2, 1. Good outcomes do not guarantee good intentions, do not guarantee good outcomes. Forcing every big multinational to file a systemic report sounds reasonable. However, until we realize that these reports are going to be defensive, not legalese. International stock markets, as we're going to explain, are a collective independent national and regional exchanges with sovereign regimes. And systemic risks are the risk that a failure or distress of one institution triggers widespread contagion across financial systems. And reporting obligations are mandatory systemic audited public disclosure of interconnected, stress-tested, and contingent. So our team contends that while systemic risk matters, mandatory reporting obligations on multinational listed corporations are not wrong approach. It is directed at the wrong target. The report will produce defensive paperwork and transparency will be disproportionate and regressively expensive. Our case split is, as per speaker, I will prove the motion is directed at the wrong target and is practically ineffective. My second speaker and third speaker will demonstrate that the success of the motion will lead to compliance costs and trigger a panic. This debate is therefore not about ignoring systemic risk. It is about whether this particular mandatory international reporting is on every listed multinational company is the right tool and is it focused on the right sector? As the proposition has argued, we argue that this is supposed to be directed at the financial sector, not at multinational corporations. True systemic risk stems overwhelmingly from banks and asset managers, not the general multinational corporation. Post the 2008 framework, the Dodd-Frank Act of the United States and the FSB designations, they target systematically important financial institutions or systematically important entities via actively based or entity-specific tools, not universal reporting for every multinational corporation. Many non-financial multinational corporations contribute only marginally and indirectly. So this forcing them to report creates noise and dilutes regulators' focus on risks, false positive, and a false sense of security. So therefore, why should we argue for something which is not progressive and something that is regressive? We do not argue systemic risk is not important. We argue that it is genuinely unreasonable with sufficient precision to generate useful mandatory reports. The world's most sophisticated financial regulators, armed with full supervisory authority and comprehensive data, cannot really and reliably identify systemic risk. So then how can we then say that focusing on multinational corporations will then produce the results that we want? What prospect is there that corporations themselves filing these reports will disclose the information which we then need? So truly, is this the right tool that we should use? And is it focused on the right sector? Or should we truly focus it on financial sectors which have a direct harm and would cause a danger on economies and the ordinary citizens? With this, we thank you.
Thank you very much. Proceeding to hear the first rebuttal, King's College London, 2 minutes.
I will start in 3, 2, 1. Honorable judges, the world the opposition is asking you to accept is one where we recognize the dangers of systemic risk, but refuse to require the transparency that is necessary to manage the risk and prevent it from materializing. Their argument is that we should simply hope that existing rules are enough to manage any systemic risks, even though global markets have repeatedly shown the consequences of these hidden risks. Firstly, they say that we are targeting the wrong actors and that systemic risks comes mainly from banks and the financial sector as a whole. But systemic risk today does not arise from one sector alone. Multinational corporations, they operate across markets, jurisdictions, and supply chains, and their failure affects not just the shareholders and investors, but also governments, individuals, and entire economies. Existing rules like the Dodd-Frank Act show exactly the opposite of what opposition claims. They show that when institutions are capable of systemic harm, the law needs to impose higher reporting and supervision requirements. Our motion simply applies that same logic from the financial sector to multinational listed corporations whose global reach creates global risk. Secondly, they argue that reporting will be expensive, defensive, and ineffective. However, reporting obligations already exist, and large corporations already assess risks internally for investors and regulators. What we are proposing is a modest and limited extension of the existing disclosure rules, justified by the scale of harm that systemic crisis can cause. After corporate scandals such as the Enron scandals, stronger transparency rules have been found necessary, and they were introduced because markets cannot function without trust and transparency, and the same principle should apply here. The cost of disclosure, therefore, is smaller compared to the cost of a global financial collapse. Exchanges already act as global gatekeepers to global capital, and they impose listing and disclosure rules already. Evidence has shown that self-regulated exchanges are associated with higher transparency and liquidity, meaning they are well placed to apply these uniform standards across borders where national regulation leaves gaps. Thank you.
Thank you, University of Lusaka, for the first rebuttal, 2 minutes.
Am I visible and audible?
You are.
Okay. I will start in reverse countdown of 3, 2, 1. The proposition wants us to believe that more paperwork means more safety. Honorable judges, they are selling us an illusion. Firstly, we will not allow the use of the 2008 crisis to justify this use. We should all be clear that the SOX targeted banks post-Enron, not retailers, not manufacturers, and not techs. This punishes non-financials for a crisis they did not create. It is a regulatory mission creep. Secondly, they might claim that investors need this info, but investors get thousands of info when investing. Annualies, quarterlies, and SOX filings. The Dodd-Frank's VOCA alone added noise. Regulators drowned, there were missing threats, and it created an illusion, not safety. Now, furthermore, they say that companies should accept the burden, that they should accept the accountability, but the succession of this motion has on costs, and firms leave public markets, go private or abroad. This allows systematics to hide unregulated. Now, we believe that billions in compliance costs for rules that would not have prevented the last crisis and will not predict the next one. That is not regulation. That is tax against public markets. It is paid by companies, it is passed to consumers, and it is vested and is wasted on paperwork. So we ask the adjudicators to vote against it. But us as the opposition will not bring out problems without solutions. We ask the adjudicators to look at alternate mechanisms, such as global state testing, systematic risk, insurance funds, and empowering whistleblowers. We ask that the proposition, we say that the motion does not allow the proposition to reduce risk. It pushes risk into the shadows, and thus it is dangerous. With that, we submit. Thank you.
Thank you. For the second rebuttal in favor, King's College London, 2 minutes.
Can I just check that I'm audible?
You are.
Honorable judges, the opposition is now telling you that reporting will only create more paperwork without improving safety, but this ignores the reason disclosure rules exist in the first place. Financial markets depend and rely on information. Without transparency, any risks will remain hidden and until they become crises. Reporting obligations are not pointless bureaucracy. They are the mechanism that allows investors, regulators, and markets to react before systemic damage spreads. The fact that past regulation did not eliminate every crisis does not mean regulation is useless. No rule is going to guarantee perfect safety, but that does not mean rules are unnecessary. Greater transparency makes crises more predictable and more manageable. They also say that rules like the Sarbanes-Oxley Act or the Dodd-Frank Act target banks and therefore multinational corporations are the wrong target. But those laws prove our principles by analogy. Where institutions are capable of causing wider economic harm, the law imposes higher supervision and reporting requirements. Today, multinational listed corporations are institutions that have the capability to cause such widespread economic harm, and their failure can affect pensions, governments, individuals, entire economies. If the risk is global, there should be a global obligation to disclose. Opposition also argues that compliance costs are too high and firms will leave public markets and start accessing private finance instead. But listing already carries extensive disclosure rule, and this has not prevented firms from going public. Large multinational corporations, as we said, already conduct risk assessments. What we are proposing is not a new system, is not an unprecedented system that does not work. It is something that already exists. Multinational corporations already conduct risk assessments for internal use. What we are proposing is a reasonable extension of the existing rules to address modern global risk that takes into account the size and interconnectedness of multinational corporations. Stronger transparency, yes, it is going to have costs, but the cost of another systemic collapse would be far greater. Honorable judges, the choice is not between regulation and efficiency, but between controlled risk and hidden risk. Thank you.
Thank you. For the second rebuttal against University of Lusaka, 2 minutes.
Am I audible?
You are.
Okay, so I'll begin my speech in the reverse countdown of 3, 2, 1. Well, the affirmative comes before us in today's debate, promising us a world of transparency. But transparency without any discretion is, in fact, a death sentence. By forcing multinational listed corporations to be able to broadcast every systemic vulnerability, where we are in then triggering more harm than more good. We are giving investors a reason to flee even before an actual solution can be found. Thereby, we are turning a manageable risk into a self-fulfilling prophecy of collapse. Now, in today's debate, we see how the affirmative came before us, telling us that if we implement a systemic risk reporting obligation, we are then giving early intervention and giving regulators more time to be able to handle the risk. But their use of early intervention is a fantasy, considering the fact that we're living in a digital world and age today. By the time this systemic risk has been reported to the public, the market would have already reacted. Now, let's take, for instance, and look at what happened in 2023 with regards to the Silicon Valley Bank collapse. We see that that bank wasn't actually insolvent, not until it reported its risks, and because of that, it led to the collapse. Their transparency didn't, in fact, lead to any intervention, but rather it led to a collapse, and the market did react. More reason why we are saying transparency, too much transparency would definitely not lead to any sort of solution. What we believe is that public reporting does not, in fact, even give regulators time to be able to act, but rather it gives them time away because a panic has been triggered. And because of that, it will be hard for them to be able to operate. What we are trying to say is that we should have professional and private oversight to be able to intervene. And that is the only way that we can have a solution without burning down the whole house. And it is for this reason that we firmly oppose the motion that systematic risk obligation should be made mandatory in conducting legal business. And with this, I rest my case.
Thank you very much. We will conclude by hearing concluding statements, starting with position in favor, 2 minutes.
Thank you. I will begin my speech in 3, 2, 1. Honorable judges, organizers, and Lusaka team, it has become clear that the key issue here is whether systemic risk would effectively be prevented via international stock markets imposing reporting obligations on multinational listed corporations. We reaffirm a position. It is only through this combination that systemic risk will effectively be prevented. First, because we have established that transparency outweighs freedom of business or potential costs. While opposition claimed that transparency would be disproportionate, making too much noise for investors, we pointed out that the importance of transparency relating to systemic risk is already acknowledged, with notably the Dodd-Frank Act for banks. It already exists, as scandals showed that the cost of collapse is just higher. Information helps investors make rational decisions and avoid crises. It does not cause it. This leads me to our second point. We established that international stock markets are the best actors to implement such reporting obligations. While opposition claimed that other mechanisms exist, such as empowering whistleblowers, such mechanisms might come too late. We established that a self-regulating market, instead, is a more transparent stock market, not to mention the efficiency of potential disciplinary actions. Prevention is key, as it allows for the containment of systemic risk before it occurs, not as we let it happen in 2008. We argue for prevention. Third, we established that it is precisely multinational listed corporations that must be regulated. While opposition claimed that multinational corporations are the wrong target, we showed that such companies play their own role in an interconnected context and are important enough that interference is necessary for it to be prevented. They are notably connected to employment and investment. Existing legislation recognizes already that the bigger the financial actor, the higher the risk. For example, Section 165 of the Dodd-Frank Act. This is why we argue in favor of a motion as the only effective means of preventing systemic risk. Thank you.
Thank you. For a concluding statement for the against position, University of Lusaka.
I'll begin my speech in the reverse countdown of 3, 2, 1. Well, as we come to the end of this debate, the proposition has offered us a very beautiful fantasy. We have painted a picture of a world that needs transparency for the global economy to be immune of failure. But what they do not realize, or what they're not focusing on, is the fact that we're living in the 21st century, and that our markets are no longer driven by the 20th century cycles, but rather our markets are driven by the speed of light, considering the fact that we're living in a digital age and world today. What then were our main arguments in today's debate? In today's debate, I'd like us to recall the fact that we referred to the 2023 collapse. That was a very profound example and proof that, in fact, too much transparency can, in fact, lead to a collapse, and it will also lead to the economy to be able to go down together with the multinational cooperation. More reason why we're saying transparency, in fact, is not a good thing for multinational listed corporations. Additionally, we also spoke to the fact that a systemic risk is primarily a financial issue. We also spoke to the fact that systemic risk is primarily a financial sector issue in today's age and world, and more reason why we are opposing against the fact that we should have a systemic risk reporting obligation. And lastly, we also focused on the fact that this obligation, in fact, imposes a direct financial strain without the proportion of benefits to the market stability. What we are trying to say in today's debate is that this motion is, in fact, unnecessary, it is ineffective, and it will then bring more harm than good, as to what the proposition are saying. And therefore, what we are trying to say is that we want a resilient market. We want a market that will be able to stand firm even without its risks being reported to the public. And it is for this reason that we firmly oppose to the motion. Thank you.
Thank you very much. You can all now relax. You're no longer graded after this spot. This marks the end of your day 3 debate, and actually the first day 3 match of this day. Well done, really well done to your teams. Well done for preparing and for executing your arguments during today's session. You have much to be proud for in your work. As always, the judges have the time to review the match and submit the scorecards. But already now, we would like to invite you to share your experiences and the feedback for the exchange today with each other, for the research, perhaps, if you were familiar with topic or aspects of it prior to the match. And in the meanwhile, I would just like to ask the University of Lusaka's team to tilt their device by 90 degrees, and thus starting with the King's College, Miss Ali.
I think this debate and the prep time went a lot better than our last debate because we were a bit more familiar with the format and we were very much on schedule. I think my teammates would agree that we were a lot less stressed out this time. As for the topic, I really enjoy international finance, so I really loved the topic. I knew a little bit about the domestic laws on finance and banking in the UK, but it was nice to use that knowledge and apply it to an international context as well.
Thank you. Same question to Ms. Kabunda of University of Lusaka.
The motion was a pretty interesting one. It was very challenging to research for both proposing and opposing and have the arguments well articulated, but I think we did well for the time we had. And I think the opposing team also did it really well. It was very nice to go against really good debaters. Thank you.
Thank you. Passing floor to Mr. Barry.
Yeah, I think this topic, unlike Afrin, I was completely unfamiliar with. Like, I had very basic knowledge of finance, nothing else. The first thing I did was check how a stock market worked. So that was pretty challenging, but it was very interesting. I think the most challenging thing in this research was trying to tie it to precise provisions, even though there's nothing about systemic risk and listing rules, for example, or like try to find cases, which was not very much the focus in this debate, unlike the previous one. So yeah, it was interesting to see a very different motion from the one on international environmental law last time.
Thank you. Ms. Mukia of University of Lusaka.
Okay, so for me, I think the motion was quite interesting, and it was easy for us to be able to work together, even though it was challenging to pick out on certain examples and authority that actually did apply to the scenario at hand. But it was quite an interesting motion, and it was easy to understand practically. Yeah.
Thank you. Ms. Garcia of King's College London, how was the exchange?
I personally found the motion quite difficult, so I thank my teammates for being so patient and helping me to understand what the debate is about and helping me prepare together. And I also found the opposition's argument quite interesting because we ourselves had different arguments. So it was really interesting to see a different interpretation of the motion. And I thank the opposition for a really good debate.
And Mr. Ndlela, how did you find the exchange?
The motion was very challenging. I had no idea of what stock exchange or anything related to it. So it was research on basically everything from the foundation of everything, on what everything is about. But it was an interesting 7 days researching and finding out and working with the team, of course. And yeah, the proposing team did a quite good job on their arguments. And yeah, it was exciting and fun. Thank you.
Thank you. And as always, we usually wrap up the session with a bit of exchange. For the first part, I would like to invite the teams to use the opportunity if there's anyone or cause or opposing team mentors or an experience that you've had that supported you or encouraged you during the competition so far. Now is the space you can give a shout out to them. So first to the King's College London team.
I think we can thank our coaches like Sophie Guzmanova and Carla Roth really did a great job of like showing us the demanding character of this competition since it was very new and the first motion our research was a bit more chaotic and we had no idea and they were here to like tell us which resources might be useful, how to approach this. So I think we should give them a huge thank you because it wouldn't have been the same without like their coaching.
Passing to your colleagues, if you want to also give a shout out to anyone.
I think maybe just my teammates. I was kind of nervous going into this about how the team would be structured, what the dynamic would be like. But I think they've made everything easier. They've responded to my texts asking questions at like 1 and 2 a.m. So yeah, so I think they've been really helpful, really cooperative and understanding. So thank you to them.
I'd like to also give a shout out to my team and the coaches, especially after the first debate. The feedback that we got, I think our coaches really ensured that we would implement this feedback into the debate today. So if it weren't for them, I don't think we would have incorporated the feedback as well. And also my teammates, they really helped with my understanding of the motion. And there were a couple miscommunications that had to be fixed a little later than we would have wanted to, but I thank them for our cooperation and being so patient with me.
And for the debate team of University of Lusaka, same question.
Okay, thank you. I'd like to shout out to my lecturer because apart from being an amazing coach, she's a very good lecturer. And initially, we didn't have full understanding of the motion, but with her guidance and leading, we were able to fully understand it and articulate our arguments really well. I'd also like to shout out to my team for all the nights we had calls and argued against each other. It was really helpful to have such a supporting team and such an easily understanding team. Thank you.
Thank you. So really well done to the two teams and of course to your support network. And just before we wrap up, over the past debates, I know for the teams in the group, there was fall through for one of the teams. They couldn't participate due to academic obligations. So you didn't perhaps have all the full 3 topics. But over the course of preparation for the debates you've had so far, and also your coursework and personal motivations, do you have perhaps an area of law or a specific country's legal system or international organization or an area that you would like to further explore, be that in your studies or in your future professional steps? So first to University of Lusaka's team.
Yeah, so personally, I have interest in international criminal law. Yeah, so but I haven't started doing international law yet. I'll do that in my 3rd year because currently I'm in my 2nd year. But currently I'm mooting on international criminal law, so it's a quite interesting field which I want to dive into. Yeah, thank you.
Thank you. Same for your colleagues, if you would like to also share.
Okay, so for me, I think I'm finding it quite interesting, especially that most of our topics are in line with international law. So for me, the field that I would like to also focus more on is basically international law itself. And yeah, get more understanding on it and learn more about it. And it's better for me considering the fact that we're debating more on such topics. So it's giving me a lot of insight. Yeah.
Thank you. Now I'm passing to King's College London.
All right.
Okay, go ahead.
No, go first.
Just over the past year, I think I've really become interested in international arbitration. It is more of an up and coming field, but I think it's still quite niche. So it's been interesting learning about something that isn't really taught so much at uni unless you take it and like pursue it actively. But yeah, hopefully I'll be able to make a career out of it as well.
Yeah, I think for me it's international like environmental law or biodiversity. I've been really interested in climate change and I've tried to have courses on this. Otherwise, like human rights in general, I think. So like yeah, international stock markets were a funny topic, but I think the first motion really I learned a lot about stuff I actually want to do later on. So I think that was very well connected.
I'm still in my 1st year, so I'm still not completely sure, but I definitely want to go somewhere into international law. But I just find it so fascinating because it has so many areas to offer. And currently, I've been exploring international human rights mainly, but I'm not settled yet on what I want to pursue.
All right. Thank you very much. I really hope on behalf of the organization that the topic so far inspired you and you take the skills and the information and also the network that you've had with the teams you've met so far further. We do have a networking opportunity going further in the mid-edition break just before the 8 finals. So keep an eye out on the emails so you can join. It's a follow-up to the January event. But without too much or too many spoilers, passing to Professor Levanche to wrap us up.
Yes, that was a very, very interesting match, and congratulations, because of course it's a technical topic, and we are very pleased actually to see that you were debating, I mean, like really expert with the resource and all the research you have done, so well done, congratulations. During the next days we'll receive, of course, the results from the judge, and we'll let you know by email. And we want to encourage you, of course, to keep contact. It's something that we highlight. two universities who participate already for more than 2 years, actually. So Lusaka, I think, 4 years, and King's College London. So your peers and former participants, I guess, already transmitted some information about the competition. So do not hesitate to follow as well maybe their advice about keeping contact. That would be useful for your career in the future, going to Zambia, going to UK. You never know. So well done, and of course we are looking forward to see you at the networking event. So thank you again, and we'll keep in touch. Thank you, bye-bye.
Well done,
Thank you.
bye.
Thank you.
Thank you, bye-bye.